Right now, millions of people around the world believe they're entitled to an Italian passport through a great-grandparent. Many of them are about to find out they're wrong. In the last year, Italy quietly redrew the rules on citizenship by descent, and almost no one explained it clearly. Here's exactly what changed, who's still in, and who just got locked out. Welcome to the Expat Ledger, where we break down the real financial and legal mechanics of crossing borders, citizenship, visas, the cost of relocating, all of it. Quick disclaimer before we start, this is not legal advice. For anything specific to your own family situation, talk to an immigration attorney. For more than 100 years, Italian citizenship by descent, known as Jure Sanguinis, or right of blood, was famously generous, arguably the most generous descent-based citizenship system in the world. The rule was simple on paper. If you could trace an unbroken line back to any ancestor who was alive after Italy's unification in 1861, and that ancestor never formally gave up their Italian citizenship before passing it down, you could claim Italian citizenship yourself. It didn't matter if that ancestor was your grandfather, your great-grandfather, or further back. Generations didn't reset the clock. That's very different from most countries, where citizenship by descent typically stops 1 or 2 generations removed from someone who actually lived there. Italy's approach meant someone whose great-great-grandfather left Sicily in the 1890s could, in theory, start a legitimate claim over a century later, as long as the paperwork held up. For a long time, that's exactly what happened, and it built an entire industry around genealogical research and document retrieval. That generosity eventually created a massive surge in applications. Italy has one of the largest historical emigration footprints of any European country, which means enormous communities of descendants today, especially in Brazil, Argentina, and the United States, where waves of Italian immigration a century ago left millions of people with a documented, technically valid claim. As more people discovered they qualified, consulates in some countries developed wait times stretching years just for an appointment. Some applicants began routing cases through Italian municipalities directly, or through residency in Italy itself, just to bypass consulate backlogs. The Italian government's public justification for tightening the rules was that the system had drifted too far from any real, lived connection to the country. Whether or not you agree with that reasoning, it's the stated rationale behind what came next. On March 28, 2025, Italy issued an emergency decree, later finalized as Law 74 of 2025, and it drew a hard, specific line. Going forward, in most cases, you need a parent or a grandparent who held Italian citizenship, not a great-grandparent, and not further back than that. The unlimited generational chain that defined Jure Sanguinis for over a century is, for most new applicants, simply gone. A narrower path still exists for people with no other citizenship and at least 1 year of residency in Italy. But for the vast majority of descendants applying from abroad, the practical effect is the same. If your only qualifying ancestor is 2 or more generations back, the door that used to be open is now closed. There's one key exception worth knowing in detail. If you had already filed your application or had a confirmed consulate appointment booked before 11:59 p.m. Rome time on March 27, 2025, the night before the decree, your case is still evaluated under the old, generous rules. That cutoff is exact, down to the minute, and it created an enormous rush in the final hours, as people raced to lock in appointments they'd been sitting on for months. Everyone who didn't make that cutoff, even by a single day, falls under the new, stricter system, regardless of how long they'd already been preparing their case. This created some genuinely strange, almost cruel situations inside the same family. Picture 2 cousins, same family tree, same Italian great-grandfather, equally documented. One cousin happens to have a living grandparent who personally held Italian citizenship before passing away, so their link runs through a grandparent, and they still qualify. The other cousin's only connection runs 1 generation further back, through that same great-grandfather, with no qualifying grandparent in between, and under the new law, they're shut out entirely. Same bloodline, same ancestor, completely different outcome. Naturally, a change this disruptive got challenged in court almost immediately. Critics argued that retroactively cutting off people who believed, often for years, that they had a valid claim was unconstitutional. In March 2026, Italy's Constitutional Court reviewed several of these challenges and rejected them. confirming that the new generational limits remain fully in force, at least for the cases that were brought forward. For descendants hoping the courts would simply undo the 2025 reform, that ruling was a significant setback, and it confirmed the new rules aren't a temporary measure waiting to be struck down. But the story isn't fully settled yet. The Constitutional Court has another, more significant hearing scheduled, where it will examine whether citizenship by descent should be treated as a right that exists from the moment of birth, one that a later law can't simply revoke after the fact. If the court rules that way, it could meaningfully reshape how the 2025 reform applies to people who were already in the qualifying bloodline before the law changed, even without a filed application. That decision is still pending as of mid-2026, which means this area of law could shift again before the year is out. So let's talk about the financial side of all this, because for thousands of families, this was never just an abstract legal technicality. It was real money, already spent, on a process that may or may not still apply to them. Many descendants had already paid for certified birth and marriage certificates pulled from multiple countries, official apostilles, sworn legal translations, and, in plenty of cases, professional genealogical research to fill in gaps the family itself couldn't document. For some applicants, that represented years of accumulated paperwork and several $1,000s in cumulative cost, all building toward a single consulate appointment. When the rules changed, some of that documentation became irrelevant overnight because the generational link it supported no longer qualifies. The paperwork isn't worthless. Much of it can still support a different kind of application, but the specific claim it was built for, in many cases, simply evaporated. There is one genuine piece of good news in all of this. Starting January 1st, 2026, Italy eliminated the €250 administrative fee that used to apply to citizenship declarations made by operation of law. For everyone who still qualifies under the new, stricter rules, that makes the remaining process meaningfully cheaper than it used to be. It's a small concession in the middle of an otherwise much harder system, but it's real and worth factoring into the budget for anyone moving forward with a valid claim today. If your generational link is too distant under the new rule, there's still a second, legitimate route worth taking seriously: residency-based naturalization. Normally, naturalizing through residency requires 10 years of legal residence in Italy. But if you have an Italian-born parent or grandparent, regardless of whether that relative later naturalized somewhere else and gave up their own Italian citizenship, that requirement drops to just 2 years instead of 10. That's a dramatically shorter path than most people realize exists, and it's frequently overlooked by people who hear they're cut off from Jure Sanguinis and assume that's the end of the conversation. It requires actually living in Italy for those 2 years, a real commitment. But for someone seriously considering relocating anyway, it can be far faster than waiting on a legal challenge to change. And Italy isn't acting in isolation here. Other European countries with large historical diasporas are quietly re-examining their own ancestry-based citizenship rules, watching closely how Italy's reform plays out, both politically and legally. Portugal, for instance, just restructured how its own descendants apply, introducing a new sequential, two-step process for some applicants that most existing guides haven't caught up with yet. If you're researching a descent-based path into the EU, the rules you read about even a year ago may already be outdated, which is exactly the trap we're digging into next. In the meantime, here are the 2 mistakes I see constantly. Mistake number 1: relying on guides, forums, or groups written before May 2025. Almost everything published before that date, describing the great-grandparent pathway as straightforward, is now incorrect, and following outdated advice can cost you real time and money chasing a claim that no longer exists in its old form. Mistake number 2: not checking whether your ancestor naturalized in another country before the next descendant in the line was born. Under current rules, that single date, naturalization versus birth order, can break the entire chain, even if every other generation in your family tree is perfectly documented. It's a small detail with an outsized impact on the outcome. So if any of this affects you directly, here's where to start. 1. Confirm exactly which generation your qualifying link runs through, not just that an ancestor was Italian. 2. Check whether you had any filing or consulate appointment booked before the March 27, 2025 cutoff, because that single detail determines which rule set applies to you. 3. If you're cut off under the new generational limit, seriously evaluate the 2-year residency path before assuming the door is permanently closed. Italy tightened its door, hard and fast. Portugal, meanwhile, took a different approach, restructuring how its descendants apply rather than cutting most of them off entirely, but creating a sequencing problem that trips up just as many people. That's exactly what we're breaking down next. Portugal's 2026 reform, the 2-step application chain it created, and what it actually costs from start to finish. If you're trying to make sense of your own path across a border, legally, financially, or both, this channel exists for exactly that. No hype, no guaranteed outcomes, just the actual mechanics and the actual numbers. Subscribe, and let's keep the ledger open.